Good afternoon and good evening on the East Coast, and welcome to what must be the world's least interesting virtual Zoom background. I'm Nick Pache, and I'm a researcher here at the Rand Corporation Institute for Civil Justice, and I want to introduce you to the panelists for this session on implications for civil litigation in the courts in a post-pandemic world. So in sort of artificial alphabetical order, Paula Hannaford is a director of the National Center for State Courts Civil Justice Initiative, as well as its director for the Center for Jury Studies. The Honorable Bridget Mary McCormack is Chief Justice of the Supreme Court of the beautiful state of Michigan. Donna Melby is partner at Paul Hastings in Los Angeles, and her practice concentrates on a very wide variety of complex business litigation. Perhaps joining us as soon as his plane lands at DFW or wherever he was headed to will be Steve Herman, who is a partner at Herman Katz in New Orleans. And his practice also, like Donna's, more concentrates on class actions and commercial litigation. Up to this point in this conference, you've listened to other panelists talk about the challenges that have been faced by courts and litigants in the COVID-19 era. In attempting to navigate the pre-trial process and impanel juries and actually hold trials. We then heard about the state and federal rules, how they have and perhaps will change to make it easier for those same courts and litigants to deal with pandemic-related court closures, restrictions on gatherings, restrictions on travel, and other disruptive events that we've faced since March. All of those earlier discussions were focused on the here and now, really about the current pandemic and either about what people are doing at the moment to deal with it or the steps that will be taken soon or have been taken to make this process work as well as it can in this COVID pandemic that we're all in the middle of right now in these extraordinary times. This panel is going to look at this at a very different way. We're going to assume that at some point, hopefully next year, maybe a year and a half from now, a group of vaccines or very effective treatment regimens will be put into place and become widely available to the point where COVID-19 becomes more on the par of seasonal flu. It's in terms of how it affects us in society. We'll take steps to not catch it. We'll take steps not to spread it. Maybe we'll continue to wear masks in a lot of different situations, but we're gonna get to the point where Americans feel comfortable enough to go back to work, to attend sporting events, to go eat at local restaurants, to get on an airplane, and basically do all the other traditional aspects of close interpersonal relationships. In that world, we're going to assume that citizens aren't going to balk at the idea of sitting on a jury panel, at least no more than they did back in 2019. We're going to assume that the judges aren't going to shy away from sitting on the bench and managing cases before them in open court with litigants in the room and the public in the room and marshals and court clerks and et cetera are sitting around them. We're going to assume that attorneys aren't going to be hesitant to sit down with opposing counsel if they can think that there's a way to settle a case before them. And if that's true, then of course really wanted to operate in a manner that's pretty similar to the way it was back in 2019, it wouldn't be impossible for them to do so. So the great big question before this particular panel is whether we'll return back to business as usual in that ideal post-pandemic world, or whether we're going to start facing challenges we've never considered in these current chaotic times, or whether we're going to use this crisis as a sort of means to reboot the civil justice system and in some way and make changes that would never have been possible to do in the past. So to answer those questions, we're going to be drawing upon this panel, which includes representatives of the judiciary, the experienced trial bar and litigation bar, and the justice-related research community. I'm going to first try to figure out what is that post-pandemic civil caseload going to look like, And so my first questions are for Chief Justice McCormack and Paula Hannaford. To the both of you, and either one you can pick up and answer first. The story we've heard since March is that courts have been moving at glacial speed in regards to the majority of civil cases on their docket. And for the most part, have only been addressing the most compelling issues in the cases with the highest priority. And so do you have a sense of how big the reservoir of cases are out there that have been essentially frozen since March, and they're just sitting there and waiting for somebody to start moving them through the court resolution process?
I can go first because Paula probably can back clean up for me and might have a better information nationally. I have some information about what's happening in other states because I am co-chairing the National Center's Post-Pandemic Planning Technology Committee. I think that's what it's called, something like that, Paula. It's the technology committee for what happens after all this. And I have a lot of colleagues from other states who sit on my subcommittees, and I'm in touch with them regularly. And I'm also in touch with the chiefs from my surrounding states weekly. But I think the answer is it's incredibly variable. It's variable from state to state, and it's variable within each state. Let me give you an example of what I mean by that in Michigan. In Michigan, we have a number of judges who are completely current with their dockets, absolutely current. Michigan passed 1 million hours of Zoom hearings 3 weeks ago. We were sort of uniquely well set up to move everything we do in the state courts online because our judges already had Zoom licenses and the hardware to be able to do a lot of what we do online. And we started doing jury trials again a couple of months ago. Obviously, they look different. We have some judges picking their juries on Zoom, and then when they get down to 12 or 14, they can have them show up in a courthouse. Some are picking them in high school auditoriums. One in one county in a ballroom, in one county in a field house, but they're figuring it out. And so there are judges who are current on their dockets in Michigan. There are also judges who keep thinking it's about over and, hoping that things will just get back to normal. That's probably not true anymore, but that was certainly true for a while, right? I mean, I think that was actually true for all of us. We had a lot of cognitive dissonance about what we were heading into, and we all kind of hoped it would be over a lot sooner than it has turned out to be. But I think it's incredibly variable across the country from what I understand. And so there are places where there is a significant backlog in dockets, civil and criminal. And of course, the in-custody criminal are taking priority and taking up a lot of the precious court time that we do have. So the answer is some places lots, some places none.
Paula, do you have anything to add to that?
Yeah, the chief has it exactly right. Just in the state court system, there's tremendous variability all across the country. I think there's probably some characteristics that we have seen that kind of predicted and make sense for which courts are doing better and which courts are really struggling with backlogs. Those court systems that had actually invested considerably in their technology infrastructure before the pandemic hit, e-filing, e-scheduling, more sophisticated case management systems. As the chief mentioned, they were actually investing in video conferencing platforms that would allow for a lot more of the hearings and online dispute resolution, for example, to take place. And those courts have actually transitioned really well to this pandemic place that we're at. We're seeing clearance rates, they're not at 100%, but they're in the high 90s, which is not horrible. However, the courts that were still really wedded to a paper-based system, and so that the only way that you could actually get a case to move and to get events scheduled is to actually walk into a courthouse with a motion to set a case for hearing or to, do something like that. When the courthouses are closed to the public, that just was not happening. And so those courts are actually having a much greater problem with backlog now because they could not make the transition just because their rules and their lack of infrastructure didn't allow them to move and be as flexible as the ones that had already made that investment.
Any sense of the proportion of these forward-thinking sort of e-court jurisdictions versus the ones that are still, I won't say they're still using 3x5 cards, but that less posed to adapt quickly? What's the balance in the United States on that? Is it most, are the e-courts the exception and the paper folks are the majority, or what?
I couldn't give you a proportion. I think probably a better way to think about some of those, what happened. A better way to think about some of that is having to do with the sort of the statewide funding. I think those courts that were more centralized have had a better job than those courts that are more fractional. Just because a lot of the local funding, you just get less ability to coordinate, less IT expertise to bring to the table in those courts that are just more fractionalized.
Donna, you practice in Los Angeles. I know you have a national practice, but to the extent that the cases that you have a caseload that involves ones in the county of Los Angeles, cases in ongoing cases in LA.
I guess I'm muted. I had to unmute there. Yes, having a national practice has allowed me to compare and contrast the impact on the different courts, the different ways in which different jurists take creative approaches to the challenges that they definitely all have faced. My home base, as you well note, is Los Angeles. And I think that in Los Angeles, the problems are, at least in the state court for sure, are unique because it is the largest court system and because it literally closed for 3 months and because we can't hold jury trials in the majority of our courtrooms and still be safe. And to me, welcome, Steve. We're glad to have you.
Nice job, Steve.
To me, one thing that hasn't yet been mentioned, and I'd be interested in the views of others on this, in a place where it is as challenging to catch up as it is in the Los Angeles Superior Court or even other state, California state courts up and down the state that are larger, it depends in some large degree too on the jurist's willingness to manage and skill and ability to manage his or her docket. I'm finding that makes a huge difference. And, you know, you're seeing a much greater even difference than we did before when you look at the really hardworking, dedicated jurists and the ones that maybe don't work quite as hard and don't take quite as much ownership of the docket. To me, in these times, that has never been more important. I'd like to hear if others have that same view, but definitely that's mine.
There's been some assertion, Donna, I've heard from folks that that once the courts get back to full operations, we're going to see a movement in these cases that a flood of litigation is going to come in from cases that could have been filed in April, in May, in June, and the like, that perhaps weren't, partly because law offices is kind of sort of shut down just like everything else, but maybe even extended out this period of attorneys not filing cases that they had on their desk for whatever reason. We're not talking about cases that are the novel COVID-19 theories of about insurance, business interruption insurance. I'm talking about ordinary litigation that you would have expected to see filed in the courts routinely week after week in the spring and summer. What I've heard is that there was that cases weren't being filed. And from your perspective as a litigator, but on the defense side, and I know you would have a sense of what just the incoming work, your workload is. Have you seen the drop off during the pandemic time of new cases that you had to defend?
I expected to, but that has not been my experience.
Good.
I think it depends upon the practice area. In my case, a lot of my practice involves complex business litigation, but a lot of nationwide employment litigation, class actions, things like that. And I've seen a tremendous uptick. And of course, COVID presents a whole host of problems for employers.
Sure.
So I've, to my surprise, been busier than ever. The challenges, there are more challenges in dealing with that kind of busyness right now, many more, both on the side of having to deal with the courts on the one hand, and things as inane as depositions. I know that, and I think these problems are going to continue post-pandemic, because I see it as kind of almost like recovering from an illness. It takes time. And I think post-pandemic, we are all going to see bench officers and members of the bar and law professors, all of us are going to see almost a healing process, because a number of things will have changed. A number of things will stay different because of COVID. Some things will change to be done differently after post-COVID, whenever that is. But in my view, that's at least another year away. Yeah. But it's going to be a process, and it, I think, can actually be a really difficult process. It doesn't have to be, but it will, because in some jurisdictions, like the one that I often practice in Los Angeles, we're so far behind that we have to start back up with criminal cases, and that's not till later. So civil trial dates that are on calendar now, everyone knows that they aren't real dates. And how things are going to work in terms, there's no case law, for example, on how to do these remote depositions that the panelists before us were speaking about. And there will be case law, because there's a lot of things that happen during remote depositions that create problems, serious problems. And we're without guidance. It's just that we know that we have to do things remotely if we want to get them done, and that no judge is going to tell us that we can't, that we have to have an in-person, for example, deposition. But there's a lot of problems, and at least in California, in many courts, we can't get those addressed. There are some judges who will, state court judges who will address those issues on a dime, but there are many who won't address them for 6 months.
So it's a story that varies depending where you are, who's managing the case. Steve, are you with us now? Are you?
I hope so.
You are.
Can you hear me?
Yes, we can.
Oh, well, I apologize for being late and for the technical difficulties.
It's all about how the story ends. Do you have a sense of what we're talking about here in terms of whether there was a change in the way new cases that were being filed during the pandemic era? Do you have a sense of that, whether your cases that you work on, did they grind to a halt, or was there some progress during the last few months under civil cases alone?
I mean, I think it depends a lot on the venue, and as Donna was saying, the willingness and the ability of the judge to press forward. In federal court, pretty much all of the motion practice continued. They didn't have, and they still aren't having jury trials, but they've had a few bench trials. state court, it's very much by venue. Some venues were affected a lot more than others, and they have different, I'll say, political outlooks and philosophies about whether and how urgently and aggressively to press on. But then within places like New Orleans, I wouldn't say they've come to a grinding halt, but they're really only doing what's necessary. All the couple jury trials I was involved in have all been continued until at least 2021. But there's still motion practice. People are still doing expert reports. People are still taking depositions. It's definitely slowed down, but there's still some progress.
Paula, I saw your hand raised up. Did you want to chime in here?
I was just going to mention that we have been getting anecdotal reports from a lot of states about what their civil filings are looking like starting in March and April and May. And we certainly saw a huge drop-off in filings, new filings, across the entire country. We were getting reports from vendor like Tyler, for example, that has a lot of the case management systems for many of the state courts. That filings were down by a third or even as much as a half in some areas of the country. As Donna mentioned, though, I think it's a lot to do with sort of what the case type is. Landlord-tenant, there was a national moratorium on for both statewide and federal for through much of the early part through mid-June. We now have a new CDC order that goes to the end of the year. And so with landlord-tenant cases are roughly about 20% of state civil caseloads. That takes a whole big chunk out. But as Donna said, if you're in working with employers that are dealing with wage and employment discrimination type cases related to COVID, those have continued, at a pretty heightened rate actually for right now.
Well, that's my next question to the entire panel. Anybody can jump in on this. And of course, throughout this session, anybody can jump in on anything. I'm just throwing it out to one person at the beginning, but this one I'm going to do it to everybody. So on that related to that, there's sort of the way I look at it, there's two types of pandemic related litigation. And there's this one that involves litigation that at least partly arises from the economic and the social aspects of it. So we're talking about debt collections and bankruptcies and tenant evictions and mortgage foreclosures and maybe even family law matters like dissolution and child custody, things like that. That's the social side. And then you have the ones that are really related to the virus, right? Not a side effect of the virus, but related to it. For example, business interruption insurance disputes, negligent exposure to the virus, say in a workplace setting, or even as a consumer going into Home Depot or something, medical malpractice, perhaps arising out of COVID treatments. You probably have other examples there. So are we going to see, and are we already seeing a big jump in those kinds of cases? Are we seeing an uptick in the number of mortgage foreclosures, an uptick in the number of debt collections, an uptick in all these other ones and also the ones that deal with COVID-19 right now? And that's open to anybody.
I'll talk about the COVID stuff for a minute. I think on the business interruption side, you may see a huge swell of cases. I think people are waiting. The clients wanted to wait and see if and to what extent there was going to be federal relief and then additional federal relief. Now that seems to be running out and they're having problems negotiating a second bill, people may feel more pressure to actually start those cases. Secondly, there were some MDL petitions that were filed and are still to some extent pending before the panel. And I think people were waiting to see how that was going to shake out. And then, thirdly, I think people are waiting to see, I think it's a very, being objective, I'm obviously on the plaintiff side and think that there should be coverage, but it's not a slam dunk. It's not like a hurricane case or something like that where there's coverage. I think there's arguments on both sides. And I think people are waiting to see how some of the early decisions shake out. And so I think you could see a huge swath or avalanche or whatever it is of business interruption cases, but you might not necessarily. On some of the other cases, like medical malpractice relating to COVID, in a lot of the states, you have laws that raise the standard where there are these civil orders. So it raises the standard from negligence to gross negligence, or maybe even higher, or maybe there's complete immunities. So I don't foresee, at least in those states, a lot of litigation arising out of COVID exposures in terms of like malpractice type suits. Some people may want to litigate other types of exposure cases, assuming that there's no immunity passed. I understand that that's a big holdup with the bill, is that the Republicans want a complete immunity. The Democrats don't want to agree to that. But assuming that there is no immunity, I think there's still some pretty decent causation issues that might deter people from litigating a lot of those cases. We'll kind of have to see how that shakes out. But as far as I know, there's been very few personal injury exposure type cases filed, at least as of this point.
Chief Justice, I saw you raising your hand.
Yeah, I think there is absolutely no doubt that we're going to see a lot of cases related to debt, evictions, mortgage foreclosures, other debt collection cases, other consumer debt cases, so much so that a lot of us are working on creative ways to handle those dockets because they're going to be overwhelming. Michigan we put the entire state into an eviction diversion program, got the legislature to give us $60,000 of CARES money to connect tenants to tenants and landlords to that funding to try and settle a lot of those cases.
Really?
But we're going to see the same for mortgage foreclosures. We're going to see the same for other consumer debt cases. And we're looking at whether we should do the same for some of those dockets. These are, of course, already dockets that are full. The eviction docket in Detroit before we had a pandemic was one of the busiest we have in the state. Also, one of the ones with the fewest litigants represented by counsel, which is obviously hard for courts and court staff, and so I think we all are going to be having to figure out what we're going to do about those dockets.
I would add, Nick, that in terms of overall caseloads, I mean, just keep in mind that at least in state courts, that really about 80% of state court caseloads are actually relatively high volume civil cases, your landlord tenant, consumer debt, small claims, foreclosure. So it's a relatively small slice of the cases that, for example, Donna and Steve are practicing in that are more, attorneys on both sides with, more complex contract and or tort issues. What we've seen in previous recessions, just in terms of the economic impact after 2008 and also after the 2001, 2003 recessions, civil filings definitely went up, sometimes by, 10 to 15% across the country, and then kind of trickled down again. So we're certainly anticipating that. But I'm not sure, sort of as you look at the overall composition, that we're going to see different, a huge increase in like new business cases as a proportion of the overall caseload.
I mean, even the ones that, I mean, the high volume, presumably low case weight, low in terms of staff time cases. I mean, the two come out to a number that's pretty big. You take all those relatively small impact to the court cases, but if there's a gazillion of them, they are just as important to the court's business as a relatively few number of business interruption insurance cases and the like. So it's a lot of stuff out there. So let me ask both you and the Chief Justice is, so correct me if I'm wrong, and this is not an area that I know much about, but court funding for the last 6 months of the pandemic, it seems to me that it's been relatively untouched, because that money was for the most part allocated back in 2019. And so it's not like the budgets of the funding has dropped immediately. But what about next year and beyond? What about are you expecting significant funding cuts for the courts as a result of reduced state and local governmental revenues? Are you expecting increased competition for the few dollars that are available for state and local agencies such as the courts because of increased competition that's related to COVID-19, such as competing demands from state public health agencies and social welfare offices and like that haven't deal with other aspects of COVID-19? In other words, are we looking for a court system in this country that has reduced capacity to deal with what sounds like, in some aspects, an increase in demand upon its resources for next year and going forward?
It's definitely not irrelevant. State budgets have taken a significant hit. I don't think it's only in this next year, at least in Q3 and Q4 of the last fiscal year, we all were asked to tighten our belts and sometimes more, give back. We had a negative supplemental here in Michigan, and that was true in a lot of places. We were able to make ends meet because as soon as COVID hit, we announced hiring freeze, spending freeze. Everybody tightened their belts significantly, and so we were able to give the legislature a little bit of funding back. But the problems continue. The programming that we were hoping to get new funding for, we will not. And the budget will take a hit this year. And I don't think it's only going to be this year. I expect, and in fact, I understand from my friends in the legislature that next year might be even worse, because the economic recovery isn't going to happen overnight. So it is a significant issue. I say this in lots of audiences. I think, though, it's giving us, therefore, every piece of it, a chance to rethink what we do and how we do it, right? The combination of all of these factors and this moment where we're all having to do things differently, forced to do things differently, we have an opportunity to really think about the ways in which we could be more efficient and at the same time more effective. Michigan happened to have, we just completed a bipartisan state and county process looking at our county jail populations, which have tripled over the last 30 years, like many states, county jail populations, even though crime is at a 50-year low, and we had made 18 consensus recommendations to dramatically reduce those jail populations. Saving money wasn't what motivated us. It was actually a better justice system and safer communities. But it turns out it does save a lot of money if you significantly decrease the number of people in your county jails and instead have them, paying their bills, going to work, paying their child support, and et cetera. So it's actually giving us opportunity, I guess, is, the answer to your budget question is yes. We're going to have a few lean years for sure, but that's just more motivation to figure out how we can do what we do more efficiently, and I think also more effectively.
We're going to return to that subject later today. Paula, is this your take on a more national basis? Are you hearing from other folks across the country a story that's similar to the Chief Justice's, where we're talking about a couple of lean years for the courts going forward?
Yeah, and I think it will go on for a couple of years. Certainly it did after 2008, and in 2001, 2002, it did continue. We do have courts that are talking about some pretty significant drops in terms of service, either closing courthouses for certain hours, reducing the number of hours that courts are available to the public, furloughing employees. But as I mentioned earlier, just the number of states that made serious investments in their technology, a lot of them did that after 2008 because they realized that you've got less resources. So instead of working harder because we don't have the resources, the money, or the staff to do that, we have to work smarter and we have to make those investments. And so as the chief said, I think we will probably see an additional push in that direction to actually become much more streamlined in the way that we operate our courts. And a lot of the senior management that have sort of been involved in the visioning of what post-pandemic court systems will look like are actually very excited about some of the innovations that may come down the road.
Well, it sounds like to you and the Chief Justice, it sounds like you've done a lot, the courts have done a lot of the easy, I don't mean easy because I know it's an incredible disruption to home people's jobs and livelihood and their families and everything else, but you've done some of the low-hanging fruit in terms of trying to save money right now. So if we're talking about a continuing spiral downward in terms of funding for next year, are we in for a real problem, more than we have seen even this year for the courts? That we're gonna, is it possible that since you're gonna have to give priority to the criminal side, and that's what we hear anecdotally, that the civil backlog was gonna have to take a back seat to the criminal and family court and unlawful detainer, whatever else has higher priority. Are we looking at a perfect storm of problems for in 2021, 22, 23 that we might not have seen before, with this giant increase or a significant increase in new work for the courts to do, including clean up what they haven't done for the last few months in some jurisdictions, and a reduction in funding to pay the people to do it?
I see only opportunity.
That's good. It's the
only opportunity.
Make that lemonade out of those lemons. Good for you. That's good. That's good. Well, let me switch. We'll come back to that in a minute, but let me switch to the two litigators here and ask them. Donna, I know that from what I know about you, I know that before the pandemic, the old days, I think that we have to come up with a new term for everything before like March 2020. I haven't figured out what it is, but I know that you've traveled extensively in your practice, you flitting across the country and racking up all these frequent flyer miles, and you met with the opposing counsel and your clients and everything else. Are we gonna, given the fact that we've had a taste of this Zoom world, are we going to go retrench from that later when things get a little better? Or are we going to see, is Zoom the new normal for a litigator like yourself that has a national practice?
I have to say that I am so happy that I had the opportunity to practice most of my career pre-pandemic. Let me just start there, because what has made my career rich, among many things, are the relationships and the wonderful people, opposing counsel, bench bar, really fine professionals that I have had the opportunity to spend time with in person. I think much of that post-pandemic will be gone, although I do think some of us will crave some kind of personal interaction and people will be excited to see each other. But I do think that forever the practice of law has been changed. And I do think that the new young lawyers who are coming in now are going to expect to work remotely. They're going to expect to make court appearances remotely. Their employers are going to save money on office space. It's going to be a completely different experience that, at least in my mind, can't help but change the experience of being a new lawyer a lawyer in our great profession. And so there's a part of me that feels sad for the newer lawyers who aren't going to get to experience what we have been so privileged to experience. And so that part of it is sad. The flip side of that is that it's a new generation. This is the way they're used to doing business. They'll like it much better. It may be more efficient in many ways if we can work out some of the kinks of Zoom depositions and the technology glitches that some of the courts are experiencing. You know, it may be a more efficient world. Will it be as civil and professional? I have a question mark about that.
I think, Steve, I think I have a feeling you have the dinosaurs perspective on this. What do you think about the fact that we're moving to a Zoom world rather than you going out for cocktails with the opposing counsel and writing down numbers on the back of a napkin? Is that, how are we going to do that with Zoom?
I mean, I personally agree with Donna 100%. I'm not sure that I'm necessarily in the majority, though, or that we're in the majority. You know, I would kind of break this down between we have plaintiff counsel and defense counsel interactions, and then we have interactions among plaintiff counsel who are co-counseling cases and they're working on cases together. On the adversarial side, for lack of a better word, you know, Donna can speak to this better than I can, but I think I would expect that there would be a lot of pressure on defense attorneys by their clients. Insurance companies and others are probably going to say, wait a second, you did this for 2 years during, you know, COVID. Why do I need to pay for you to fly around the country and meet with people and take depositions when you can do all of this remotely? Why am I paying all these travel costs, et cetera? On the plaintiff, so if they're not going to do it, then there's no reason for the plaintiffs to meet them anywhere. So then among plaintiff lawyers, I think you probably have, you know, we kind of control our own pocketbooks. And so I think you'll have some dinosaurs like me that will crave and want the personal interaction, because I do think it's very important. And I also think that you know, that's been very rewarding for me. But you have other lawyers, plaintiff lawyers, maybe they're old, maybe they're young, whatever generation they are, who are kind of waking up and saying, look, you know, what have I been doing all these years? You know, I mean, I like practicing law, but it's at the end of the day a paycheck. I'd much rather spend time with my family, and I don't need to be flying all over the country, staying in hotels and going to dinner and doing all this stuff. I'd rather just get on a Zoom call for 2 hours and take the deposition. So you have the road warriors that like being road warriors and the congeniality, and you have others that resent it. I do think, you know, this is both. It's a sad day for some of us, but I think it also creates opportunities and efficiencies. At the end of the day, it's going to probably save money. Is that, you know, the great thing at the end of the day? I don't, you know, it depends on your perspective at least. But I do think it's going to be different. We went through something like this, you know, in New Orleans and the surrounding area in 2005 with Hurricane Katrina. And the practice really did change a lot, not necessarily in this way, but I think a lot of people woke up. There were no courts. We were all over the South and around the country. And we woke up and we said, you know, I don't have to live in New Orleans to practice in New Orleans. As long as I have an internet connection and I can get to an airport, I can live and practice remotely. And a lot of people who are still New Orleans lawyers have essentially practiced remotely for the last 15 years. So I see that happening even more now. People just waking up and saying, I didn't have to do all this stuff. Some of us will miss some of it, but, you know, it is going to be good for some. And it's certainly going to save money for better or worse.
Let me keep the focus here on the two litigators here. So the two of you, this question is not about your law firm specifically, so you don't have to give away any secrets here, but I want to talk about what you know about the litigation bar in general. Do you have a sense how the pandemic has affected adversely law firms in a way, like in terms of staff size or internal policies or practices, for example, cutting out all travel and the like? that it's going to continue to persist in the next few years, even though COVID will go. Let's assume COVID goes away. And for example, you've reduced the size of your office staff down to something really small, and is that likely to be maintained in the future? That size, even if business picks up. You just talked about Steve about working remotely. You were gonna if COVID triggered that, you're probably not going to go back to making the drive on the freeway to go downtown anymore. Anything else you've seen in your practices that has been triggered by COVID that you think is going to be true about your firm and the like, go down line 2 years from now, 3 years from now? Either one of you?
Donna?
Well, I would say, and I come from, my background is a large international law firm. And I would say that the trend will be, for sure, for much more work away from the workplace, much more remote work. I think the offices have every year been getting smaller and smaller. The workspace is smaller and smaller. And I think that's going to continue. There is still a great need for a lot of support staff, but they can also, by and large, work remotely. So I think that major law firms will probably be losing some real estate. In other words, why pay for all that space when it's not really getting used? And I think that the acceptance of having people not be in the office every day or even most days is going to be very much the norm and very accepted, as long as people keep up their productivity. Now, the challenges are, when you have young lawyers, they need mentorship, they need to be checked in on, they need to have communication with more senior lawyers, and it's the partner's responsibility to make sure that happens. And I'm guessing that some people are probably better at that than other people, but there will be those kinds of challenges, at least in large firms, and I think in mid-sized firms too. But again, I think the amount of work in firms is, at least in my firm, has been really, really high and still very demanding. And so, again, I think that's not always the case, though. I think it depends on the practice area. So I think we're seeing some firms that are downsizing or losing some people, but there are others that are hiring. I have a nephew who's a third-year lawyer who's coming from Washington, D.C. to California, and
got a job.
Different process, and when you're interviewing during COVID, but it's people are still hiring.
Good. Well, that's good.
But other people are laying off, so it's interesting.
It's always this mixed bag. Let me ask one more question before we move on to another subject here. We just talked about something that's not so nice, which is reduced staff size. I mean, maybe in the long run that's better, but it hurts to let people go, I think, in my opinion. But are there positive aspects of COVID-19 world that you'd want to see continue in the future? I'll give an example. That you found that the bench and the bar are a lot more collegial, that they're more understanding and they're more eager to compromise, and they've probably seen all the commercials on TV, how we have to love each other and love thy neighbor and all this other COVID-related stuff. Is this something you've experienced and you would like to see it continue, or is it just business as usual and everybody's out for themselves and yada yada yada? Or is there anything else that's happened that you'd like to see continued because you think it's been good now and be good later?
Well, I'll start with that. Internally, I think it's been eye-opening for some of the partners and some of the older guys and ladies that to be a little bit more understanding of the staff and that they can work remotely. And, you know, in our office, I think for the foreseeable future, we're going to continue to let people work remotely as long as they can get their work done. And it's just so much more flexible for them in dealing with kids, et cetera.
Right.
And so I think that's probably been positive. On the professional side, I kind of think it's a little early to tell. You know, one of the things that Donna talked about, and I think maybe we might be talking about this a little bit more later on in the hour, is, you know, a lot of the camaraderie that's built, in my experience, among adversaries, among the plaintiff counsel and the defense counsel, is on all of the downtime and the off time and the interstitial time that doesn't really exist in the Zoom world. You log on, you have your conference, and you log off. There's no sitting around in the hall for a half an hour before and after where you can talk, or driving to the deposition together from the airport, or, you know, having dinner together after you've taken the deposition. All of those types of things I think might get lost a little bit. But on the other hand, and on a positive side, for example, in New Orleans, almost immediately, we had the managing partners of probably, you know, the 30 or 40 biggest law firms or major law firms on conference calls every week, and on email, you know, listservs, plaintiff lawyers, defense lawyers, everyone sharing ideas, sharing impressions, sharing strategies about how to deal with COVID. And so it has brought some collegiality, but I just fear over the long term, as you get into these higher pressure situations, when we start having trials and the pressure's really on, and you haven't had that time to really become a friend with the person that's sitting on the other side of the aisle from you, I'm not sure how well that's going to work out. We'll just have to see and hope for the best.
Donna, your experience or anything to add there?
I don't disagree with anything that Steve has said. For me, there are some question marks because I don't know what's going to happen with civility and professionalism when all of your contact is via Zoom, especially if it's not somebody, or if they are not lawyers that you've had already time with to get to know. That worries me. I don't think that it really is a worry on the criminal side. But on the civil side, I think all the judges who I've had the opportunity to talk with all tell me that criminal lawyers are much more civil to each other to begin with than civil lawyers seem to be. I'm not sure why that is. Maybe because it's a smaller community or whatever. But assuming that to be true, and assuming that civility and professionalism is still a challenge in our profession, which I think it is, and an important one, very important to our continuing profession and to our reputations in the larger community outside the practice of law. I don't know what this whole electronic interaction is going to do to that. I would love other people's thoughts about it, but to me, there's still a big question mark.
Well, let's unless someone has someone to follow up on here, I was going to suggest that we switch gears a little bit, and let's talk about maybe rethinking the civil justice system. I'm going to first of all talk about basically the digital revolution in terms of the courts. I think it's fair to say that most courts have been relatively slow to embrace the digital revolution the same way that private businesses and governments to some extent have been, in terms of the storage and transfer of information, transmission of information, allowing remote access to court records and the like. Unless I'm wrong, I mean, my sense is that electronic filing is far from universal. Online dockets, thankfully, a lot of courts are beginning to have them, but often they're very crude. They're just a few words about something that occurred. You don't really get a sense of what actually happened in the court that day, or what document has actually been filed. And the ability to view and download papers and pleadings is pretty uncommon. I, and Paula and the Chief Justice can correct me, but I can't think of any state court that matches the federal PACER system in terms of a one-stop shopping center window on the activities of a court system. So, is there a sense now that the movement to the digital courtroom, I think that everybody agrees is a good idea, has been accelerated by the pandemic, or is this something that is such a disruptive time that it's been difficult for courts to take that next step in terms of with the uncertainty in funding and new demands and fewer people in the building and more difficult to find vendors and the like? Are we actually slowing down from that progress? Let me post that question first.
I think we are speeding up. Absolutely. We've seen more change in the last 6 months in the state court system than in the last 3 decades. There's no doubt about it. And not only change in what we specifically do in our courtrooms, but change in the way we think about what we do. I mean, I couldn't agree with you more that for a long time we were really successful lawyers in courtroom and court judges and courts in particular were really successful at resisting the tech revolution that came for every other industry. If you look at courtrooms right now, they look a lot like they did in 1918. We've just been able to stave it off. I think only education might be, competing with us for how successfully we have resisted coming into the modern world. And then all of a sudden that changed, and everybody has had to figure out how to do business. Courts can't close. They can't just close. So we all had to figure out how to do business for the last 6 months. And in addition to trying all new ways of doing it, we tried and failed lots of things and had to try again. We all have been acting like entrepreneurs for the first time. We're all trained. There are lots of reasons why we resist change. And I think a lot of them are really good reasons. They're, cultural, they're normative, they're legal, right? We're a profession based on the past. We are guided by past decisions. So we're the opposite of entrepreneurs, right? In fact, we're usually the bummer in the entrepreneurs conference room. Usually the entrepreneur is like, do we have to keep her in here for this part because she's going to be a bummer? But all of a sudden, we have all in state courts been like, I don't know, let's try that and see how that works. I mean, we threw up online dispute resolution statewide in Michigan in 2 months. We have an online dispute resolution platform that is free, and every Michigan resident can use it for any small dollar case. Wonderful. Remember, the state courts, just in Michigan, the trial courts adjudicate between 3 and 4 million cases a year. 3 and 4 million cases a year is a staggering number of cases that have to be adjudicated even in a pandemic. So we had to try things, fail, try again, tweak them, try again. I think we have accelerated both the pace of change and our approach to change. And all of that is going to benefit the public who use our courts, most of whom don't have the benefit of the awesome lawyers that join me on this panel right now. Most people use courts without lawyers because they can't afford them. In Michigan, 8 out of 10 people can't afford lawyers for their civil legal needs. And we're going to be able to better serve all of them as a result of this accelerated change.
Paula, I see your head nodding.
Yeah, yay. No, I think part of the dynamic here for a lot of the judges, especially that were very resistant to technology generally. I have to have the people in court because I have to be able to control and I have to be able to see them. And when they were forced to go to video conferences, and particularly, as the chief mentioned, with high volume dockets that have lots of self-represented litigants. And two things, and this is all sort of anecdotal right now, but it's widespread anecdotal that we were hearing from the judges and court staff. Typically on those high volume dockets, upwards of 80% or more are uncontested default judgments. Just failure to appear, one side or the other, so they're either dismissed or default judgment out of hand. And so you're only working out of every 50 cases that might be scheduled for this, 9 o'clock hour. you've only got really 8 or 10 cases that, at most, that you would actually have to have a 3 to 5 minute hearing on. All of a sudden, when they went to video conferencing, that flipped. And you had 80 and 90% of the people actually appearing on the telephone, in the video conference, you know, from their cell phone. And it just sort of dawned on people of what these technologies mean when you actually reduce the, you know, the time and the cost and the logistics of arranging for childcare and taking the day off from work and finding parking to actually get to an in-person hearing, when you come in and you wait for an hour and a half, and, you know, and it's a really tumultuous, chaotic environment, and people are sort of yelling and moving around in the back of the courtroom, that this was actually a really normatively good thing for access to justice. So I think that just really flipped on a whole bunch of lights about the possibilities for actually improving access and improving outcomes for people who really could engage in the civil justice system. So I think that was a big one. The other one that I think is probably driving a lot of this, and the chief mentioned this as well, is that these are cases, at least in state courts, probably less in federal courts, that you do have a lot of self-represented litigants. And so the lawyers in these high volume, you know, these high level cases that are very, very complex, are not the primary constituent anymore. And so courts, you know, it's sort of like being in the emergency room in a hospital. You can't actually turn anyone away. And all of these cases actually need to be dealt with in a fair way. And so it's really incentivizing courts to think about, how do we streamline and rethink not how we build courts and court rules and business processes for the most complex cases, as we heard in the previous session about, you know, a lot of the federal rules are actually built around how to manage multi-district litigation, which is this tiny, tiny little sliver of cases even in the federal court. But how do you actually put together a court system that works for most of the cases that are actually being filed, so that you are addressing those in a fair and reasonable and timely and cost-effective way? By doing that, you free up the resources and get the needs work for those cases, but you also free up resources for those sliver of cases that actually do need more judicial attention.
Well, Chief Justice, do you have any sense that these pro se litigants, when they do appear on a video courtroom, is it just about the difficulties of finding the child care and pay the ridiculous parking that you folks charge at courthouses across the country? Or is it something about the fact that it's a one-on-one? You know, it's a video with you, video with them, nobody else in the room, not that giant August, you know, impressive marble and deep dark wood kind of thing. Is there something about that makes it more attractive to pro se litigants?
I can't wait to understand what it is, and I'm not sure how to disaggregate all the pieces of it. I think for some
you could hire the Rand Corporation to study it.
Okay, great. I mean, I think for some people, finding childcare, parking, taking time off for work is really complicated. I can't tell you how many judges say that they have litigants who will appear on their phone in a break room, and they're so grateful to the judge that they were able to appear in court without having to take a day off work, because they didn't have the kind of job where they could take a day off from work. But we've also anecdotally heard from lots of judges that there are certain litigants, self-represented in particular, and kids in particular, who are just far more comfortable in this format. And I guess it makes sense. Like, courtrooms are scary, right? They're even scary for lawyers sometimes. Imagine how scary they would be for kids. You know, I have judges with child welfare cases that say, you know, I've had this young girl on my docket for a year and a half. I've never gotten her to say a thing. Now all of a sudden she can talk to her phone, and she wants to show me her homework in her room, and she's, you know, giving me all this information. There's, you know, something far more comfortable for litigants, and perhaps people who don't have a lawyer next to them in particular, in navigating a virtual courtroom. We've also heard anecdotally that the fact that the Zoom boxes are all the same size makes everybody feel like they're on kind of equal footing. It's like an equalizing force, the same size Zoom boxes. But I don't know, there's a great paper there if we had any data on this. It's a really interesting paper. I sometimes want to just be an academic. I have to like be a judge, but I want to be an academic. So,
you know, in this headlong rush to an electronic world, is there any worries that, for example, I know the courts need to pay for this. So I have seen, in my experience, court after court putting up, I don't know what you would call it, a paywall, but it's a pay to play. I have to, you know, they want to make the money back for the infrastructure they're sticking in there, and you wind up, you know, it's not that much to me, but might be a lot of money to somebody who's, you know, a litigant. Maybe you're waiving it for there, but you're moving away to a technology-based access to the court. And if you put up paywalls, if you make it so that you have to have the latest technology to connect, is there any danger of that happening, where we're gonna start shutting out folks who maybe that we're baking in the inequalities that have existed for, you know, 200 years of American jurisprudence by having an increasingly heavy reliance on technology?
Paula, you want to start?
Yeah, I would. I actually think a lot of those concerns about the, you know, pay to play and how do you actually fund your court system that we trickled in through the criminal side. So a lot of the court fees and fines and bail practices that started churning out and basically caused Ferguson. The underlying, you know, when you actually looked at the Justice Department's Civil Rights Division report on Ferguson of what was going on with terms of local court fees that were being used to basically prop up the municipal courts there. So the state courts have really looked very long and hard at some of those, and I think there's been a real turnaround over the last 6 or 8 years to say, no, we cannot fund ourselves through litigant fees, whether it's on the civil side or the criminal side, that this is fundamentally unfair. We are public courts and we need to be accessible. And so whether it's a matter of, you know, revising the practices for can you afford to pay and looking at fee waiver type programs, both on the civil and the criminal side, but also on the filing fees, or just saying, no, we're just not going to, we're not going to increase our fees, we're going to decrease our fees. So I think we've been ahead of that, and I don't see that changing because of the pandemic and because of the need for technology.
Before the pandemic, if I can remember that long ago, I know that both state and federal courts were at least experimenting with a lot of different kind of civil justice reform efforts. I'm not talking about tort reform. I'm talking about reimagining certain aspects of civil procedure with the idea of reducing cost and delay and improve access to justice. Has the pandemic sidelined those initiatives and sort of set us back at all in moving forward to try to think about new ways of imagining the court systems? This is to you, Paula.
No, actually, I think it's accelerated it. Donna and I worked together very closely for a number of years on a Conference of Chief Justices Civil Justice Improvements Committee that came out with recommendations in 2016 for really, you know, comprehensively revising and reimagining the civil justice system. And it was kind of ironic that there's been some pushback from the bar to try and implement some of those recommendations, mostly because those recommendations were squarely around the court taking control of case management in a really serious and consistent way that I think made a lot of the practicing bar kind of nervous, because it eliminates a lot of opportunities for gamesmanship that can sometimes work to their advantage. The courts that have actually put in place pilot projects have found them to be remarkably successful. And as courts are now looking at those that have backlogs and looking at a potential increase, significant increases in civil filings, coming over the next year or two, and reduced budgets to deal with them. A lot of the courts are saying, no, we need to ramp these up now, because we will not be able to judge our way out of these backlogs. We can only manage our way out of these backlogs. And here we've got here's the toolkit. Let's go.
That's good. And what about your civil justice initiative? Are you getting much traction in the COVID time, or is it you're happy with the way it's moving forward in this sort of environment?
Yeah, I mean, these are the ones that I think they are accelerating right now. The courts are embracing them wholeheartedly, and looking at here are the rules, or here are the business practices that we can put in place now.
Okay. Chief Justice, let's get back to your lemonade that you're making out of these lemons here. Is there some way we can pivot and use this crisis to improve the courts and civil justice system? Can we rethink about how to resolve the vast majority of disputes that are out of there, so that the resolution is done faster and fairer and with less transaction costs, both for the litigants and in terms of court resources?
Yeah, absolutely. And there are a lot of energetic, creative, innovative people working on that right now. The National Center has a number of us working on exactly what this all should look like when we come through this emergency period. And in our states, we are too. At least I know a lot of us are. I mean, we in Michigan, I have a task force set up to figure out what rule changes, what legislation we need to put in place permanent new processes that we've learned we can pull off, and that might be that we know are that increase access, increase transparency, and increase efficiency. I think the most important thing is that everybody understands, and it seems like everybody does, we're not going back. So let's work together, the bench and the bar, to figure out how the next version of this civil justice system, Civil Justice 2.0, is just better for the public who relies on us. We have a real opportunity here, and it's exhausting, but I think it's so well worth it, because I really think we can come through this serving the public better than we have ever been able to before. Our access to justice problem has a real opportunity now to get solved.
That's wonderful news. Any final thoughts from our panel here? I don't want Steve to get a cramp in his hand by holding that phone up for too much longer. And I see Dean Chemerinsky is coming online. So Donna, Chief Justice, and Paula, and Steve, do you have anything you want to add at this point about what we're going to see down the line when, thanks to God and good scientists, we get to the point where COVID-19 is just a kind of a blur in our memory? Any final thoughts?
Well, this is Donna. I have to wholeheartedly second what the chief just said. I do agree that we have a huge opportunity here, and it's ours to embrace, though exhausting, as she mentioned, or not. And I'd like to be able to say that we've seen consensus on it all, but I think Paula will be able to confirm that we don't have total consensus. But I am encouraged, as I hope others are who are on the panel and outside the panel, that we have seen a number of jurists and members of the bar embrace these innovative, creative, and I believe absolutely necessary changes to the better administration of cases, from the landlord-tenant and the debtor kinds of cases, all the way through the complex litigation matters that we were talking about earlier.
Steve, final thoughts? I think you're on mute.
Oh, sorry about that. No, I agree with all that. I guess my one caveat would be, and I completely agree with the recommendations that it's a problem when you're subjecting, a lot of these small dollar cases with pro bono or self-represented pro se litigants to rules that are designed for, full-on adversarial litigation between lawyers. But at the same time, when we're moving into the 21st century and we're providing better access and better justice to that 80% of the litigants, we should also be careful not to convert those 20% of adversarial cases into what I'll call more administrative cases, because it's very important for people to get access to justice for all types of things, as we all are aware. But at the same time, the cases that are fully litigated have reached beyond just those parties. Those are the cases that result in hopefully safer products and different business practices, and not just case law being developed, but also those types of changes that go beyond just resolving the dispute between and among the two parties that are actually before the court. So that would be my pitch.
Okay. Paula, you're it.
Nothing to add, Nick.
We said it all. I want to thank my panelists. Wonderful discussion, especially given the late an hour on the East Coast. This is a lot more interesting than watching some stupid baseball game playoff or NBA final. This is far more important. So thanks for being with us today. And to my panelists, so would you please turn off your mute and your video, turn it off as well, because now we're going to hear some concluding remarks for the day from Berkeley Law Dean Erwin Chemerinsky. Dean, it's all yours.
I know it's been a long day, and I know it's late, especially for those on the East Coast, so I'll keep my concluding remarks brief. Preserving the integrity of the legal system and access to justice in these times is enormously important. I often like to think back to January 1st of 2020, and we couldn't have possibly imagined where we would be on October 1st of 2020. That's true for us as an educational institution, and it's true for the courts and their vital mission. And that's why it was so important to have this discussion today about access to justice in the courts in a time of pandemic. I must again thank the Robert L. Haybush Endowment for providing support for today's program. It highlighted so many of these challenges and also showed us how we can be nimble and creative in finding solutions to them. I'm grateful to Rand for co-sponsoring this with us and being such a wonderful partner and collaborator. Grateful to all of the speakers and panelists who made this such a terrific day. And most of all, I'm grateful to my colleague, Ann Bloom, who's the executive director of the Civil Justice Research Initiative, who put this on. And I'd be remiss if I also didn't thank Thembi Ann Jackson and the event staff who coordinated all of the logistics behind this. Today, we heard so much that's important and that should give us a basis for planning and thinking about the future. We heard in the panel about juries that, especially during times of crisis, juries are more important than ever for democracy. We heard about some of the challenges of conducting jury trials in the midst of a pandemic. It was also troubling to hear about the effect of COVID-19 on the diversity of jury pools. That there's anecdotal and other evidence that suggests that COVID jury trials have had panels that are significantly more white. We need to think about this. I want to go back to something Judge Kuehl said this morning in terms of the importance of courts being there for people during times like this, and how important it is that we both have courts available and convey the message that courts are available right now to people. In the second panel, Judge Fogel led an important discussion about pretrial case management and what can be done. One of the things that we learned about is the problem with lack of access to courts just in terms of trial dates. Not having trial dates is a real problem for litigants as they try to move forward without the push of a looming trial. I worry in many courts where it's a combined civil and criminal docket that the delay in having criminal trials will make it ever harder to have civil trials. One of the things that was striking on the plus side was how much the panelists talked about, I think the phrase was the humanizing informality that virtual pretrial court proceedings have brought, and the sense of pride that there is in people doing their very best to adapt. I certainly see this in classes or administrative meetings where children come into the screen or dogs bark, and it shows how much we're all in this together. The panelists were uniformly convinced that some of the changes, such as remote hearings, are going to be with us to stay, and we may need new rules to accomplish that. In the first panel of the afternoon, there was a discussion of proposed changes to the civil rules. I'm grateful to the member of the Civil Rules Committee who described the work of the advisory committee of the last few months, including the agenda for what proposed changes to the civil rules are being considered. One of the more interesting discussions and important ones was whether there's a need for an emergency rule or whether the existing rules are flexible enough to deal with the current situation. And I especially enjoyed the last panel and also the expression of optimism for the future that many of the panelists expressed. They were discussing the impact for the long term, and can we use the lessons from COVID-19 to expand access to justice? Though these are extremely challenging times, I would say they're the most challenging times of my life. Many of our panelists were so hopeful that we could use this moment as an opportunity for lasting constructive change. If this moment can be time for expanding access to justice, if those reforms for access to justice are truly lasting, then something good will have come out what in so many ways is a tragedy. Can't think of any time in my life when courts have been faced with such extraordinary challenges in attempting to create access to justice. And yet I was encouraged. I listened to the last panel as I heard what's being done, how it's improving access to justice, and how indeed these may be reforms for the long term. So I want to end on that hopeful note. And I want to end as I began now and as I began this morning by expressing my enormous thanks to all of you who made this such a wonderful day and such a great conference. And from here, we go forward. Thank you.